rise. Court of Appeals Division 1 is now in session.
Please be seated. Morning, counsel. Let me call the case. It's consolidated case number CV 53 and CV 150341. This is Viad Corp. v. MoneyGram et al. Time set for oral argument. And just so I'm clear, for MoneyGram, it's Mr. Cabianca, if I got it backwards.
Mr. Weimer.
Okay, that's why I asked. Okay. You mind if I just make a note here? And then, so Mr. Cabianca.
Correct.
Via, okay. Thank you, counsel. You both have 20 minutes to present your argument. Counsel for appellant, you can reserve some time for rebuttal. We've read everything. We've discussed the case, so we're very familiar with the issues. I will advise you that these proceedings are being recorded, audio and video. They're uploaded to our website, so the arguments that are made here today will be available to the public if they went to that website. With that being said, counsel, your argument.
May it please the court, my name is Martin Weimer. It's my privilege to represent MoneyGram here today. This case arises from a 2004 transaction, I know your honors have read the briefs, in which Viad, a corporate conglomerate who at one time owned such American iconic companies as Dial and Greyhound, decided to spin off a wholly owned subsidiary, Travelers Express, and create a brand new company, MoneyGram, which would be a public company, and that company was born, so to speak, on June 30th of 2004. As part of the transaction, Viad had MoneyGram sign an employee benefits agreement, or EBA, in which certain pension benefits, primarily in supplemental executive retirement plans, were MoneyGram was assigned the obligation to pay benefits under those plans, or at least a portion of the benefits under those plans, based on the terms of the EBA, and most notably for purposes of this appeal, based on the terms of the actual employee benefit plans. And there's no dispute that they are ERISA-governed plans. At issue here is the parties' dispute as to the portion of retired Viad CEO Robert Bohannon's supplemental retirement benefits MoneyGram's responsible to pay. He gets over $91,000 a month in supplemental executive retirement benefits. MoneyGram takes issue with $34,000 a month of that. And MoneyGram, 3 years after Mr. Bohannon's retirement, in the spring of 2011, discovered that it had been overpaying under the terms of the Viad plan and stopped paying, and this dispute ensued. MoneyGram submits that it's manifest that the claims regarding Bohannon's benefits are subject to ERISA's broad conflict preemption provision, 29 U.S.C. 1144A.
The federal district court disagreed. The federal district court disagreed that there was preemption.
Your Honor, the federal district court disagreed that there was complete preemption. As the court likely is aware, the federal courts, the Supreme Court for years, and this court in Satterley recognized there's two types of ERISA preemption, complete and conflict. The federal district court, recognizing that complete preemption is a jurisdictional provision, that there wasn't complete preemption there because Viad, and we don't contest this, didn't have standing to bring the claim, and that's a fundamental component of complete preemption under both U.S. Supreme Court precedent and the precedent emanating from this court in Satterley versus Life Centers of America. The issue here is whether it's subject to conflict preemption, which is distinct, as recognized by the court in Satterley and the Supreme Court countless times over the years.
Wasn't that issue raised, though, in the district court? I assume conflict preemption was raised.
Yes, and the trial court in this case got it wrong. She specifically ruled.
The district court, I said.
The federal district court, we're not contesting the federal district court's decision that complete preemption didn't apply here.
But did you raise conflict preemption before the federal district court?
No, we asserted that the federal district court did not have jurisdiction that the state court didn't have jurisdiction at all because it was completely preempted. And under Arizona law, conflict preemption is a component of complete preemption, but you also have to have standing.
But then why not simply take the case back to district court and argue about conflict preemption there? Why would we decide the preemption issue?
Well, we tried to get in federal district court, and the court said it didn't have subject matter jurisdiction because complete jurisdiction didn't apply, so it couldn't have decided our conflict preemption.
So what's the effect?
defense.
Let's say you win on conflict preemption. What's the effect of that ruling?
Then the case, conflict preemption is a defense to state law claims. Viad has sued MoneyGram under our state law contract theory. The case would be dismissed. Then Viad would have a choice on its hands. It could sue us in federal district court, and if it doesn't have standing, Mr. Bohannon, as a plan participant, could sue us for the benefits that he claims is owed. He'd have standing to sue.
Well, he's already receiving his benefits.
He's receiving his benefits, so there would be no need for him to sue. Bohannon's getting his $93,000 per month. Viad would pay $34,000 of that. MoneyGram would pay the balance, $57,000 of that.
So what you're asking for here on preemption is a ruling effectively that the federal district court didn't think about the second type of preemption, conflict preemption, and it should go back and think about that.
I'm not contending that, Your Honor. I'm sorry if I wasn't clear.
Well,
the federal district court would not have had jurisdiction to consider conflict preemption because complete preemption didn't apply. The federal district court did not have subject matter jurisdiction, so it would need to look at MoneyGram's defenses. And conflict preemption is a defense to state law claims.
all right.
Ultimately, Viad itself as a party may not have a remedy under ERISA, but its lawyers drafted the EBA. There are lots of cases over the years where federal courts have recognized that Congress wasn't concerned with providing everyone with a remedy when it drafted a clearly expansive conflict preemption provision.
Counsel, let me ask you kind of a different question. Then, if we turn to conflict preemption, your argument focuses on a textual application of the relate to phrase. And as I read your brief, you disagreed that travelers is really the correct approach. And in travelers, as has been discussed in the briefing, travelers disfavors just relying on the textual analysis of conflict preemption, the phrase relate to, and it guides that we need to go to the underlying principles of ERISA. Now, in terms of whether travelers is a law or not, before any supplemental authority was provided, I looked at Gobil, the new case of March 2016. The United States Supreme Court applies the traveler's analysis. That's the latest weighing in on it. I've looked at every case that the United States Supreme Court has decided since travelers. They all cite travelers with approval. And in Arizona, when I look at the Satterley case, it talks about, in paragraph 8 of that decision, that we have to look at the underlying objectives of ERISA, which is exactly what travelers says. So my question to you is, are you still standing by your position that travelers isn't the proper law and doesn't provide the proper test in deciding conflict preemption?
Judge Gould, I'm not contending travelers is bad law. It just didn't result in the sea change that Viad suggests. Travelers, there's two, as the court in Gobil that you recently read recognized, there's two categories of relate to preemption: reference to a plan and connection with. In the connection with cases you see, like in Gobil and Travelers, Egeloff in 04, which postdated both Satterley and Travelers, a state statute that's way out on the periphery, like Travelers. It was a surcharge on patients' hospital bills. And in those cases, the Supreme Court said the reference to prong really doesn't apply here. It's the connection with. It's out on the periphery, so the language relate to isn't very helpful. So let's look at the underlying policy basis of Travelers. In Egeloff, it was a divorce statute, state statute, saying that it would, once you're divorced, you can't be the beneficiary in life insurance. In Liberty Mutual, as you know, it was requiring health plans to report into a database. That was all those cases involved the connection with prong, and Travelers, Egeloff, Liberty Mutual, all applied the policy basis search for intent of Congress on the connection with problem. This is a reference to case. There's never been a Supreme Court reference to case where they have resorted to the policy basis rather than the literal language. But let's look at the policy basis. There's two, the Supreme Court has repeatedly recognized, and Satterley Court recognized, two policy bases for ERISA. Uniform body of benefits law. Everyone recognizes that there's never been a court that hasn't recognized that Congress was concerned with the interpretation and administration of plans being an exclusively federal concern. That's the major policy basis of ERISA, and the other is the protection of beneficiaries.
Participants and beneficiaries.
Yes. Let's look at the first policy basis, uniform body of law. VIAD is asking this court to decide two vigorously opposed interpretations of the language of the VIAD plan. What does final average earnings mean in the VIAD plan? What does credited service mean in the part of the VIAD plan that applies to Bohannon?
Hold on now, counsel. You only get there if you find an ambiguity in Section 4.01. I mean, if in fact this is a dispute under the EBA about who pays, and if that Section 4.01 is unambiguous, then you don't need to get into the plan.
Your Honor, may I?
Yes.
So glad you asked that. Under 4.01, no, you don't need an ambiguity to look at the plan. 4.01
Counsel,
itself.
that thing falling off that bar is so distracting to me right now.
4.01
I've got a copy. Counsel,
specifically directs parties.
I've got a copy right here.
4.01 specifically directs the parties, specifically directs VIAD to use final average earnings as that plan is used, as that term is used in the plan. So let's look at what final average earnings says in the plan. It says base salary plus commissions plus bonuses earned and paid during over a 5-year period. You have to interpret the plan to calculate Bohannon's benefits.
Okay, so
you don't need an ambiguity in the EBA.
So
The EBA directs you to the plan.
Okay. So the phrase then in Section 4.01 that says that your client would assume all obligations for the benefits, still, I mean, that's pretty clear. But I know then it goes on and it talks about plan terms. So I guess what I'm asking you is, does that create an ambiguity in terms of which obligations they're assuming? What's your argument on that?
It absolutely does not create an ambiguity.
Okay. So
What 401 is crystal clear on, 401B, is to current VIAD employees, which Bohannon was at the time. He was the VIAD CEO. You look at MoneyGram's responsible for all obligations, you're correct, arising under the VIAD plan. So naturally, it has to arise under the VIAD plan. VIAD couldn't say to MoneyGram, oh, pay Bohannon an extra $100,000 a month because we thought he was a good CEO. It has to arise under the VIAD plan. So you'd have to refer to the plan in that instance. It then says, using final average earnings as that term is used in the plan. And that's what we're disputing on this 150% kicker issue. What does final average earnings mean in the plan? We're not saying we don't know Bohannon benefits. We're saying we don't know him the benefits attributable to that 150% kicker because the plan and the EBA say use final average earnings as that term is defined.
Which is really base salary, right?
Base salary, commissions, and bonuses earned and paid over a 5-year period. And, our position, and I know that Justice have read the briefs, our position is there was a side agreement, an employment agreement between Bohannon and the board, arrived at 6 months before the spin when MoneyGram wasn't born yet. So this notion that MoneyGram intended and evidence about MoneyGram's intent in entering into the transaction, that makes no sense to me. The MoneyGram wasn't born until June 30th of 2004. It couldn't have any intent until midnight of that day when the deal was signed. So whether or not when VIAD's lawyers drafted a registration statement to tell the markets, hey, in 6 months we're going to have a public company called MoneyGram, and buried in that was a reference to Bohannon's employment agreement, that had nothing to do with MoneyGram. MoneyGram wasn't even born. But in any event,
Graham's DNA, isn't it? I mean, didn't MoneyGram inherit that?
That's a good way to put it, Judge. It was in its DNA, but DNA can't have intent. An unborn, regardless of one's position on that controversial issue, an unborn can't have intent. MoneyGram did not exist in December of 2003 when the registration statement was filed.
No, but is the intent of MoneyGram relevant? Isn't the text of the agreement and the documents to which it refers what's relevant?
What's relevant is what the EBA says.
Okay.
What's
right.
relevant is what the plan says. The EBA says use final average earnings.
But not what the other documents say about what final average earnings are.
Not documents offered. If this were a trial, I would object that the registration statement or testimony of VIOD directors leading up to the spin, who then were named MoneyGram directors after the spin, that their testimony isn't probative of MoneyGram's intent prior. There was no negotiation, therefore intent is not probative of anything.
But how far does that argument go? That gets MoneyGram off the hook for essentially everything, doesn't it?
MoneyGram's responsible to pay what the EBA and the plan says it should pay. No more or no less.
So are you making really then a summary judgment argument, just sort of a basic summary judgment procedural argument, that what we have here is a dispute of fact?
What we have here is a dispute of law. With respect to the Bohannon claims, in the words of Judge O'Connor in the Ingersoll-Rand case, there simply is no cause of action if there is no plan. If there's no VIOD plan to interpret or refer to, or if the VIOD plan doesn't exist, MoneyGram's claims can't survive. This case is an even more compelling case for conflict preemption than was presented in Satterley. In Satterley, it was employees suing over the employer's failure to remit premium payments for health insurance plans.
You know, Counsel,
and nobody disputed the language of the plan.
But in your own brief, and I was looking at it this morning, you don't dispute that Mr. Bohannon is entitled to these benefits.
You're right, Your Honor.
You believe that he is entitled to them under the supplemental agreement. He's not a party to this case. This is simply a dispute between you, your client, and another commercial client over who pays.
That's correct.
And you're saying that that is subject to ERISA, that that's a conflict preemption case when nobody's disputing the benefits, the amount of the benefits in terms of what Mr. Bohannon's entitled to, not in what you're supposed to pay or you're required to pay. There's no assignment here. That seems like a classic case of a situation not involving ERISA, that it's not preempted by ERISA. I mean, if you're going to talk about any ERISA plan being in any way remotely involved in a case, any reference to it at all, then I would go back to what the court said in Travelers. There's really no limit to what Relate To applies to. It's almost like some deep, profound concept of what could it possibly exclude.
Well, Judge, the court in Satterley said if the factual basis of the cause of action involves a benefit plan, it's preempted. This is not some tangential remote surcharge on patients' hospital bills like in Travelers. VIOD can't sue us unless they're asking the trial court. They asked the trial court. Now they're asking this court. Pages and pages and pages of their brief are devoted to trying to convince the court that their interpretation of the VIOD plan is better than our interpretation of the VIOD plan.
So a plan contracts with two payment processors, companies that just write checks to send out benefit checks to pay plan benefits. A dispute between those two payment processors over who's supposed to send out November's check is subject to conflict preemption because the basis is a plan? They're sending plan payments, but nobody, again, is disputing what happens under the plan. They're just disputing the mechanics.
There doesn't have to be any reference to the VIOD plan in that instance. It also doesn't involve a challenge to plan administration. That's not even an independent basis for conflict preemption. As the Satterley court recognized, a claim is subject to conflict preemption if plan administration is being challenged. VIOD has asserted repeatedly below, and part of the trial court's finding here was that VIAD's interpretation of the plan should be entitled to deference because it was an ERISA plan administrator. It was an ERISA plan administrator. It's arguing that its interpretation of credited service and final average earnings in the VIAD plan, that their interpretation should be given deference because they're acting as administrator. The Supreme Court ruled in 2004 in the Aetna versus Davila case that determining and calculating benefits is an essential plan function. And we're challenging that determination.
Except you agree on what the benefits are.
Of course we do. It's $91,000 and change per month. We agree on that. We disagree that under the governing documents, including the plan, that we have to pay $34,000 of that. It is a commercial dispute between two entities, but the existence of the VIAD plan is a critical factor.
The way you say that is very careful. You disagree that you have to pay $34,000. If I'm understanding you correctly, you don't disagree that Mr. Bohannon's entitled to the $34,000.
Mr. Bohannon is entitled to $91,000 and change under the VIAD plan.
So you do disagree then, as a matter of fact, that he is entitled, that the factual predicate for that additional $34,000 exists?
He's entitled to $91,000. There are facts that entitle him to the difference between the $57,000 we're paying and the $91,000. I'm not trying to be difficult.
Okay.
There is a factual predicate for that. There's a factual
Just a question then of how much you're responsible for.
That's correct.
Okay. So how is that a plan dispute?
Because you can't resolve, no court can resolve that dispute without interpreting the plan. And that makes it preempted. Look, I'd like to go back a little different way if the court will indulge me. When Congress enacted the conflict preemption provision, it did consider a more narrow provision, specifically that conflict preemption would apply whenever state law claims relate to subjects covered by ERISA are involved. They chose the broader one. If it has any relationship with, if it references or has any connection with an ERISA plan, the claim is preempted. This isn't a remote case like Travelers. In fact, it is a much more direct relationship to a plan than Egelhoff or the Liberty Mutual case, where you were 5-6 steps removed from application or involvement in the plan. This case, VIAD can't articulate its theory as to why we are liable. The trial court, if we had a trial, could not have ruled for VIAD without agreeing with their interpretation of final average earnings and credited service under the plan. Therefore, it's subject to conflict preemption.
Okay, Mr. Wyman, you're out of time. Let me hear the response, and then if we think you need some more time, we'll take it up then, okay?
Thanks, Judge.
All right, Mr. Cabianca?
Good morning.
Why don't we start there? I mean,
Okay.
with the issue of whether or not the CBA, this agreement between the two companies, can be resolved without interpreting the VIAD plan.
Well, what we're asking you to interpret and enforce is the EBA. The EBA references the plan and incorporates some of the plan's terms, some of the definitions in the plan. But nothing that this court decides, regardless of what way you decide, will have any effect on the plan, on the administration of the plan, on the beneficiaries. All of the administrative decisions with respect to the plan were made years ago. And so,
But let me kind of jump in. I'm just
Okay.
trying to follow your train of thought. Now, some of these cases deal with coverage. What's covered, what's excluded, benefits, that type of thing. Is that part of the argument you're making? Is it nothing we determine here will decide what benefits, what coverage, what any type of retirement benefits any employee will ever receive under the plan?
no, that's already been decided. And those beneficiaries and those retirees aren't plans. VIAD's been paying those benefits for years. And so that decision won't be affected by this case at all.
When I read the MoneyGram briefs, the way I saw their argument sort of backing into the plan was when you look at Section 4.01, it has this broad language that MoneyGram shall assume and be solely responsible for all obligations to pay benefits to VIAD employees under the VIAD plan, I'm paraphrasing some of it, using final average earnings, cover compensation, and credited service to the distribution date. And so part of the argument that I read in their briefs was, well, the plan does limit their liability or their responsibility to pay Mr. Bohannon's benefits. And therefore, you have to, I'm just laying out the argument, I want you to explain it. Therefore, you have to get into interpreting the plan to understand what the limitations are in Section 4.01. Now, how do you respond to that argument?
I don't think that MoneyGram is arguing that the plan has those limitations. I think their argument is the EBA has those limitations on their obligations.
Right.
And with respect to those limitations, credited service through the distribution date, to the extent that a credited service applies to any calculation, MoneyGram is only liable through the distribution date, through June 30th, 2004. We agree with that. What they're saying is, in the case of Mr. Bohannon, credited service isn't part of the calculation. It's not a factor. So when his retirement benefits were determined by the age at which he retired instead of how long he had worked with Fiat. So credited service doesn't impact that calculation.
Let me stop you there for a minute.
Okay.
Now, what I would suspect the argument is, there you go. You have to go in, the court has to make a decision on whether the retirement benefit is an age 58 and above benefit or whether it's a covered service benefit. I understand your argument on why it's an age 58 and above, but the question that troubles me in this case is, are we drawn in to construing those terms to understand what Section 4.01 means, and does that draw us into a preemption situation? And if it doesn't, tell me why.
Okay. The first question, you could be drawn into interpreting those terms. If MoneyGram contested the plan required, that if MoneyGram contested that Mr. Bohannon was being paid the proper amount under the plan, you could be drawn into interpreting those plans. They don't contest that. I mean, he just said that Mr. Bohannon's benefits were $91,000. That's what we've been paying him. That's what VIAD is the plan administrator decided years ago. So you could be drawn into that. It's still, even if you were drawn into that, even if they were contesting it, which they're not, it still would not be ERISA preempted because you are interpreting the EBA, which incorporates the terms of the plan. You're not deciding, you're not making determinations as to the plan and to the beneficiaries of the plan. Judge Swan gave a hypothetical of the service providers providing. Another hypothetical that kind of put this in perspective for me is if a seller of a car sells a car to someone and the buyer, his pension benefits are fixed. So he says, I'll buy the car for 50% of the amount I receive under my pension benefits. They sell the car. The next month, the buyer doesn't pay, and he never pays. He has the car, he stops paying. And the seller sues him. He would respond, well, in order for you to determine how much I owe you, you would have to interpret the plan and how much I'm being paid. You're not allowed to do that because Congress, their argument is, Congress intended by enacting ERISA to prevent you from suing on that breach of contract. So I have the car, I don't have to pay you a dime, and you can't sue me. And Mr. Weimer said MoneyGram's argument is that, well, VIAD could sue in federal court. No, we can't. There's no subject matter jurisdiction. The federal court's already told us that. And he said Mr. Bohannon could sue MoneyGram. No, he can't. He's not in privity with MoneyGram. Mr. Bohannon's agreement is with VIAD, and it's with the plan. And the EBA is simply a reimbursement where MoneyGram agreed to reimburse VIAD for the benefits due under the plan.
I have a much more pedestrian question for you, though. Let's assume that there is no preemption. Why is this a summary judgment case? Why isn't this dispute over the interpretation of the EBA a factually intense question that the record doesn't resolve conclusively?
Okay. It is not. It's a summary judgment case because interpretation of a contract is a question of law. There's no dispute about the facts on what the facts leading up to the signing of the agreement, whether it's ambiguous or not. Just to be clear, there is no evidence supporting their interpretation of the plan, either before the spinoff and after. And Mr. Weimer, okay.
No,
Okay.
again, I'm not on preemption.
Okay.
Okay, let's assume we're not worried about interpreting the plan. What we're really worried about interpreting is what portion of the undisputed benefit MoneyGram is required to pay. Now, I understand there's been a reference to course of performance evidence. There's been a reference to some extrinsic evidence about the inclusion of the basis for calculation in public filings, et cetera, et cetera. So I understand why you have a case. What I don't understand is why that case is undisputed.
Because there is no factual dispute, and it's just a question of simply interpreting the EBA. There's no, what's the factual dispute?
Well, it sounds to me like both sides are saying there's no factual dispute, which ordinarily should give us a cozy feeling about summary judgment. But both sides are saying there's no factual dispute, and the facts are different.
No, both sides are saying that the agreement is unambiguous for different reasons. They say it's unambiguous supporting them. I say it's unambiguous supporting us.
Okay.
But the fact.
Help me then, why is it unambiguous based on undisputed facts that the 150%, you each have different terms for it. There's this kicker. I forget what yours is. But why is that, from your perspective, undisputed as a matter of law, a requirement under the EBA?
Because to determine someone's final average earnings, you have to look at their base salary. To determine their base salary, you have to look at the employment contract. And the employment contract here says Mr. Bohannon's benefits shall be determined by using 150% of his compensation. So, and there are no disputed facts. I mean, Mr. Weimer said that the MoneyGram wasn't created when it filed the SEC. I mean, MoneyGram used to be called Travelers Express, and it changed its name, but it existed before that event. And every single email before and after the transaction, the board members on their side and our side all agreed that our reading of this provision is correct.
Thanks.
You're welcome. Any other questions about preemption? And just to talk about on the summary judgment point, just to reiterate that a little bit more. I mean, there just is there's no testimony, there's no emails, there's no documents that support their reading. And their reading, it's also not a summary judgment case, just to answer your question, because I'm focused on it. We also argued waiver before, that same evidence, the emails, the SEC filing, the emails where they were asking, that are attached to the appendix between 197 and 203, where they're asking internally, how is this to be calculated? And MoneyGram is acknowledging it's to be calculated. Mr. Bohannon's entire benefit is being paid by us. We argued that same evidence and course of performance and the fact they paid it for 3 years, that all goes to waiver. And we asserted waiver in our motion and our reply. MoneyGram never responded to that argument. They submitted no evidence to the contrary, and they submitted no legal argument to the contrary.
I think Judge Gould has a question for you.
Okay.
Okay, so as I understand Mr. Weimer's argument, he does argue that Section 4.01 is unambiguous, but he reads it this way. MoneyGram shall assume and be solely responsible for all obligations to pay benefits to VIAD employees under the VIAD plan using final average earnings, cover compensation, and credited service. And what he says is, you didn't do that. You didn't bill them according to final average earnings, cover compensation, and credit service. You violated the agreement because you threw in this 150% kicker or equalizer, I forgot what you called it in your brief, and that's not in here. You were supposed to bill them based on final average earnings and covered service. So taking the contract as unambiguous, you breached the express terms of it.
Right. So, and that's arguing about how the agreement should be interpreted when there's no disputed facts is a legal question for the court.
I'm not asking you about
Right.
that. I'm just asking
Okay.
about who's right.
And so they read it. So take, for example, credited service.
Don't you have a chart somewhere that you can pull out, Mr. Weimer? Go ahead.
Take credited service. The Section 401 doesn't say if credited service isn't a factor, it does not say this. If credited service isn't a factor in someone's calculation, MoneyGram's not responsible for it. What it says is if credited service is used to compute someone's, if it impacts someone's benefit calculation, you need to use credited service only through the distribution date. The only through the distribution date is the further limit there. So in Mr. Bohannon's calculation, credited service, if you look at the plan, and there's no dispute about this, if you look at the plan, credited service isn't part of the calculation. So it doesn't impact the amount credited service through the distribution date or at any period of time doesn't impact his numbers. And MoneyGram is trying to say, well, then we're not liable for it. But that's not what the agreement says. The EBA doesn't say if credited service isn't used, we're not liable for it. And in fact,
if applicable is what you're saying. If
Correct.
credit service applies, then
correct.
then you would be required under Section 4.01 to apply it, right?
Well, that's potentially true, yes. But everyone knew, and all the documents show going in, that Mr. Bohannon's benefits didn't include credited service. And so there's a lot of evidence showing that MoneyGram knew that before and after the transaction, that it wouldn't be applying to him.
Doesn't this section simply state that you have to assume the obligations to pay benefits according to the plan? And here are some terms that are discussed in the plan. Isn't that the essence of your obligation? Or, excuse me, of MoneyGram's obligation? They have to pay for benefits under the plan, which include all these terms: credited service, final average earnings, covered compensation, as applicable.
Correct.
That's the gist of it, isn't
So
it?
in other words, if we were, is it your position that if we were to accept MoneyGram's argument, we would actually be limiting the plan in Mr. Bohannon's case?
I don't think that MoneyGram is arguing that
I
the
don't
plan
think
is
they're,
wrong.
I don't think they're arguing that, but is that a consequence of their argument?
That if you adopted their argument that would limit the plan in some way?
Yeah, because if their argument is they're only obligated to pay benefits using final average earning, covered compensation, credited service, and in the case of an employee, let's take Mr. Bohannon, that those terms aren't relevant to the calculation of his benefits under the plan, that we would actually be taking too narrow a view of the plan and intruding on some forbidden federal territory.
No.
Okay.
That's not my position, because if you said that the EBA, that those requirements that somehow limited what MoneyGram is responsible for, you'd be saying that the EBA limits their responsibility under the EBA. The plan is what it is. You can't, any ruling you have wouldn't affect the plan. The plan's not a party to this case.
No. But we would be taking an apparent conflict of terms within the EBA if we were to interpret it, right? The conflict between pay all benefits and pay benefits calculated in such and such a way, we would be taking too restrictive a view of what all benefits are under the EBA.
Correct.
That's what I understand you to say.
Correct.
Okay.
I think I understood you. So you're.
Go ahead. It's difficult. These are difficult concepts to express succinctly.
So I guess if none of what I understood you to be saying would be a restriction on the plan.
No. But it would be a misinterpretation of what all benefits under the plan means.
MoneyGram's position, and I feel goofy, but here's their position, that the EBA is a restriction has restrictions on all benefits due under the plan. They're saying that the EBA provides further limitations than what the plan does. That's their position.
I think that answers my question, and I think they may take a different view in a few moments, but I'll be interested in that view as well.
The other issue that there's a few minutes in, if I'd like to save some time on my cross-appeal rebuttal if Mr. Weimer is going to get back up. But the other issue I wanted to talk about briefly is the 10% interest under 44-1201. on that issue, the trial court applied a 4.25% interest. And prior to the 2000 amendment, we don't think that the 2011 amendment applies to us under design trend, which was Judge Wake's decision, because this obligation was incurred in 2004. The statute on its own terms applies to obligations incurred after 2011. But if the court does decide that it applies, we think that it still requires a 10% interest rate in this case on VIAD's claims, and here's why. Prior to 2011, the statute provided that interest on indebtedness or on debts. Wait, let me just find the language. It said interest on loans, indebtedness, and obligations. It said interest on loans, loans, indebtedness, judgments, and obligations is at 10%. So what the 2011 legislature did in 2011 is they took that single word, judgments, out, because according to Metzler, they wanted to limit the application, the 10% interest, and remove that from judgments. And Metzler's a Supreme Court decision that interpreted ARS 12-1201. And so that's all it did. And if you take out judgments, this is still an interest on an obligation and indebtedness, and therefore we think the 10% still applies.
All right, thank you, counsel.
Thank you.
Mr. Weimer, let me, 3 minutes? 3 minutes? I'm going to give you an additional 3 minutes.
Thank you, Judge. 3 minutes, I'll make 3 points, hopefully.
Okay. I apologize. I said Mr. Wyman before. I apologize.
It's okay, Judge. My colleague, Mr. Cabiantia, pointed to the plan in defending the credited service issue. The EBA 401 says, pretty clear, and the parties don't dispute this, MoneyGram's only responsible, not for all obligations using credited service through the distribution date or the spin. So Bohannon, who everybody agrees worked 4 years after the spin, we're contesting the part of his benefits that were enhanced by him working those 4 years, continuously serving credited service for those 4 years. That's the part that we're contesting. It's the lion's share of what we're contesting. And Mr. Cabiantia, perhaps inadvertently, but it's been a position throughout the case, their general counsel was deposed. And when I asked him, why does Bohannon get money after the distribution date? The EBA says only through the distribution date. He says, well, you have to look at the plan. The plan has a separate calculation for Bohannon. And when you read that plan, it's clear he's exempt from that in the EBA. Mr. Cabiantia just pointed the court to the plan. And if you look at the plan language, we're both contesting whether when you use the 58 and over benefit, it says works continuously. We say that's the same thing as credited service. They say it isn't, but they're asking the court to decide between two competing interpretations of the over 58 benefit. They can't win on that issue without their interpretation of the plan being accepted.
Mr. Weimer,
that's why it's preempted.
I understand. Let me ask you this question. What goal is served by taking this dispute as an ERISA dispute? How are plan participants benefited or helped in some way? How is this uniform system of regulation over ERISA plans benefited by taking this dispute and putting it under ERISA?
Judge Gould, I'm so glad you asked that because I neglected to address that in my opening remarks. Got a little sidetracked by the question. Congress was very concerned with a uniform system of plan administration. If the trial court's decision is upheld, then the Arizona courts will have opined on the interpretation of the VIAD plan. Maybe obliquely, but they have endorsed VIAD's interpretation of the plan. Well, the next time there's a dispute between MoneyGram and VIAD as to whether Joe Schmo is covered by the plan, and we say, boy, we look at the VIAD plan, he's not listed in here, we don't think he's covered, then maybe we sue them in state court in Texas because we're based in Dallas. And I have the feeling that VIAD's going to contend the claim's preempted, that a Texas state court shouldn't be interpreting the plan. And let's say that dispute involves credited service. And the Texas state court may take a view different than the Arizona court. Now you have a plan administrator faced with two different state courts interpreting the language of the plan. And then some participants in New Mexico. And we have some of our retirees in New Mexico, I didn't just pull that out. Then they sue in federal court as plan participants. And then the federal district court in New Mexico has a different interpretation plan. That's precisely what Congress was worried about. As to the protection of beneficiaries, that factor's neutral. Bohannon's protected here. There's no doubt he's owed $91,000 and some change. This dispute is whether under the plan, final average earnings and credited service mean what we say they mean, their literal interpretation, or what the plan administrator says they mean, and the only way to resolve that is to interpret the plan, and therefore the claims are preempted. I was told by my mentor many years ago to be impassive at the table. The juries look at you, judges look at you. I see Judge Swan caught me nodding or shaking my head, and Mr. Cabianca characterized MoneyGram's position. I would like to quickly address that. It's our position that you have to look at the plan and that credited service, the EBA does have limitations, but the only way to determine if those EBA limitations are met is to interpret the plan. If they're right and the term credited service or the definition of credited service isn't used in the part of the plan that relates to Bohannon, then they haven't violated the EBA. And we've violated it by not paying. But that depends on an interpretation of the plan. Last point, really quick. Hermanson, nobody's addressed. He's one of the add-ins, and the parties addressed that in the brief, that they added a couple of participants in toward the end. We're claiming that the court's decision didn't apply to them. But when Judge Swan asked questions about whether this is a summary judgment case, it did remind me on Hermanson. VIAD did not introduce any evidence showing Hermanson was entitled to any benefits at the trial court level. They inadvertently, their only attachment was a letter from us saying, we don't have any record of Hermanson. So it was certainly improper for the trial judge to include Hermanson in the summary judgment.
All right, thank you, counsel.
Thanks.
Mr. Cabianca, really the cross appeal wasn't addressed in that argument, so.
There were some, Your Honor, there were some issues
I know,
raised about Hermanson that he didn't raise in his opening. If I could address those, if the court doesn't think that'd be helpful.
I think we're done, okay?
Thank you.
I appreciate it. Counsel, I appreciate your arguments. We'll issue a written decision in due course. Court's in recess. Thank you.